recording. So as I mentioned, this is Legacy Conversations. This is the March edition. So Legacy Conversations is the goal is truly to start conversation. I've noticed in my life and even in working with clients, there is a reluctance about talking about death or planning for death or even illness and just kind of the what ifs of life. And there's a lot of times that people don't think about it or even talk about it until it happens or it's a little too late for the planning and then everything is more reactionary. So the goal with these conversations is to share information, but also to help encourage people to be more comfortable having the conversation. I always like to say it's best to have that conversation with yourself because you got to get comfortable within yourself to be able to just kind of acknowledge, yes, I am human, and at some point I am going to die. There are people that I care about that care about me. So, what are my goals? What are my desires for while I'm alive? In the event that I become ill, either temporarily or long term, and then about when I pass away. And then the same, what do my loved ones want for me? Um, So that's like I said, that is the goal is to just to provide information. And then if there's questions that you have, you can ask those questions as well. So this month, the goal is are still just going to be talking about estate planning general with, like I said, just general overview of what estate planning is, what is a legacy. And so I'm going to pull up some slides just because I know that some of us are more visual. I like to start it. Estate planning is what it is, but I always like to start with legacy. So, what is a legacy? The definition of legacy is it's a gift by will, especially of money or other personal property, and it's something that's transmitted by or received from an ancestor or someone from the past. The legacy. That is what I like to say. That's the Merriam-Webster, so to speak, definition. But legacy is that, but for me, it's more than just what is it in terms of physical, tangible things. But it's also about who you are as a person, how you are. I think the saying is, people won't always remember what you gave them, they'll remember how you made them feel. And so to me, that's a part of the legacy. And so if part of your who you are is if you are someone who is a caretaker or you are looking out for others, then you want to make sure that as much as possible you're doing that while you are alive and that can continue once you pass away. If it is your work ethic, if it is a business that you've created, a passion project, an organization, or a program you've created while you are alive, and it's something that you want to make sure it outlasts you, then there are things that we need to do today to secure that and ensure it's able to continue after we pass on. So, like I said, so those are the things when I think of legacy, that's what comes to mind. I'm happy to hear more about what others think about legacy as well. And so when we're talking about legacy and estate planning, I always like to start about like, what is it? How is it defined? And then add my own Latavia spin to it. But estate planning is the action of arranging a person's life before their death. And some of the goals of that is it minimizes the effects of gift or estate tax. It from a more practical standpoint, it alleviates some stress and anxiety around what happens because when someone passes away, we are grieving. It is a difficult time in and of itself. But then if you add on, hey, they passed away and we don't know, they didn't have a will, or we don't know where the will is, or we don't know what they wanted, then also having to sort through and figure all of that out in the midst of grieving, it just adds on a whole nother level of stress. So that is why we plan to help minimize those things. Okay, have you ever heard? I grew up hearing if you fail to plan, you plan to fail. So we don't want to plan to fail. So that's why we are having these conversations now so that we can become equipped with the tools and knowledge we need to be able to make a plan. So I like to break things down into two categories when we're talking about planning. There are life documents, and then there are those for after death or legacy documents. With life documents, these two, I'll talk about two. They are not the only ones, but some of the kind of core, when we're thinking about just kind of the core components of a legacy plan, that's your advanced medical directive or healthcare power of attorney, depending on what state you live in. But that one, it's instructions for how you want your healthcare to be handled when you are no longer able to take care of yourself. And so you can be as simple as just appointing a healthcare agent and saying, hey, I want person A to be the one making decisions for me in the event that I'm not able to. You can go further by specifying what you want to happen in certain situations. Oftentimes we hear of, does someone have a DNR, a do not resuscitate? So you can specify whether or not you want to be resuscitated, whether or not you want life-sustaining measures to be taken, or if you don't, and you can go through and kind of specify in various scenarios what you want to be done, who you want to be appointed, whether you want to be an organ donor or if your body donated to science or you don't. So you can get very detailed with those instructions, but at bare minimum, you want to at least designate a person to be your healthcare agent. And then you want to make sure you tell that person that you have designated them as your healthcare agent because they need to know. It's also good to have conversations with them up front to letting them know what your thoughts are, what your desires. So once that if you keep in mind of how can I try to make life a little bit easier down the road for myself and for those that I care about, that will help kind of guide those decisions. The other document I want to talk about is a power of attorney, and this is giving someone written consent to act on your behalf, on your authority. And so that is generally this comes up when we're talking about finances or legal matters. So one of the more common uses for a power of attorney is being able to talk to you financial institutions on someone being able to talk to you financial institutions on your behalf. If it's real estate transactions and some legal matters, they can speak or sign on your behalf. Now it is, what is it, to whom much is given, much is required. And giving someone power of attorney is a large responsibility. So with any of these, you don't want to grant that power lightly. You want to make sure that it is someone that you trust that has a good, sound financial understanding and knowledge and who's not going to just go and do things frivolously. Because once you give them that power, you grant them that power, they can act on your behalf as though they were you. Some other things to keep in mind when we're talking about life documents, especially if you have children, is their standby guardianship, where you can it's essentially filing papers with the court to say, hey, in the event that something were to happen to me, this is who I'm nominating as a guardian of my child. Or if you have someone who has special needs that you are the caretaker for them, you could put that in place for them as well. There's also, excuse me, HIPAA authorization forms. Those are some other things that come to that you might want to consider in terms of how to operate things to be in place while you are still alive. Excuse me. Um, look at that. So I'm going to talk about what is a will, and then I'm going to stop the slides and just kind of see if there's any questions. So a will, this is most often the thing that people think about when they're talking about estate planning. It's a will is a written document with your instructions for how you want things to be handled when you die. The general requirements across the board throughout the United States is you must be at least 18 years of old and have the capacity to enter into a contract for that will to be valid. That's first and foremost. And then for once it is created, you need to sign it and then it needs to be witnessed by two people. You want to make sure that the witnesses are people who are not going to inherit from your will. There's not necessarily always a hard and fast rule that says it cannot be anyone who stands to inherit, but it's a good rule of thumb or a good practice because if in the event that there is a challenge to your will and one of the people who signed as a witness is someone who is benefiting or inheriting from that will, that gives a stronger argument for someone who wants to say that there was undue influence when the will was created. So it's always good to have uninterested parties sign as the witnesses. Okay, so as I said, next I'm gonna stop these slides. Let me stop sharing my screen for now. Okay, so this is where I will open it up in the sense of, how to have the conversation. As I mentioned, I think it's important to start with having the conversation with yourself of what do I want? Do I want to be buried? Do I want to be cremated? Do I want to be an organ donor? Um, are there people that I'm taking care of right now that I want to make sure that they will be okay once I pass away? Or if I get sick and I can't work for an extended amount of time, how am I, do I have things in place to be able to pay, make sure the bills continue to get paid? Or if you have children or pets, or like I said, or people that you are the caregiver for, are there provisions in place to make sure that they are still good? So like I said, getting a bit more comfortable with yourself. And then when it's time to have the conversation with your loved ones, I put there on that slide, rip the Band-Aid off of just have it. I don't know of any, and trust me, I have given it some thought of like, what are some smooth, sexy ways to bring up talking about death. I don't know that there are any. It's going to be awkward and uncomfortable, I think, initially, but it's just better to just start. Like, hey, have you thought about what happens when you die, or what if you get sick? If I have anyone listening who is a business owner, what happens, especially if you are a solopreneur, it's just you and your business, or it's a small team. If I get sick and I can't work, what happens? Or if I need to be away for a while, do I have someone who can help to keep things going? Or do people know where to find things in that respect? So I want to pause here and see, do you have any questions in terms of just what I've already talked about, or if there's just maybe a burning question you've had prior to about estate planning overall, or things with respect to having the conversation.
When it comes to the will and registration of the will, so I guess the registration of the will is just to have, I guess, someone else to have a copy of it, or is it something that is required?
No, great question. So registering the will, it's not required, but it is something I would say a kind of an added step. So for those who are not familiar, may not be familiar, registering the will, it would be registering once your will is completed and signed. You can register it with your county's register of deeds office, or register of wills. It's called a little different, something different everywhere. But there's an option to register it. And so the benefit of registering it is, yes, there is someone else. So, the county has it and they will have the original copy. And so the benefit there is that you don't have to keep up with it yourself. You don't have to, you really just want to make sure people know that it's registered. And so that way, when you pass away, they can contact the county and say, hey, she had a will, she registered it with the county. She's now passed away. We want to pull the will so that it can then be entered into probate. It is I think it was $5 a couple years ago. It might be 10 now. So there is a fee to register it. But if you decide to register your will, I would say it's always good to have copies, because, like I said, the county will have the original, but you still want to make sure you have a copy of it so you're aware of it. And then also to make sure that at minimum, the person you are identifying as your personal representative, that they know what's in it, or that they know that they are the personal representative. So they can just have a little bit of heads up of what that entails. And I guess as I'm talking about that, also just making sure, I want to talk about what the role of the personal representative or an executor of an estate is. And they are the person or the people who are designated. It's their responsibility to make sure that the wishes in the will are carried out. And so that could be that they themselves, take the will, open probate, and go through the process and manage everything themselves. Or if they're, like, hey, this is a little too much, or I don't really know, they can also hire an attorney or another professional to handle the probate process on their behalf. But that is that response. They're essentially, they are tasked with making sure everything in the will happens as designed. So if it's making sure that, if you leave in your will, you divide up, let's say, the items in your home. It's on them to make sure that all of the people listed in the will get those specific items that they are transferred to their possession. So, like I said, any other questions?
Sure, one more. So sometimes there's going to be changes. So the codicil, is that also an extra cost to make changes?
Yeah, so great. So a codicil, yeah, that is essentially it's a kind of an addendum to the will. Some states do accept codicils, others don't, but it is, in most instances, it is going to be an additional cost, especially if you're hiring an attorney to prepare it. What I would say is with all of my estate planning services, there's a 3-year window kind of review built in. And so if we prepared your estate plan and then within 3 years, something changed where you're saying, I want to make an amendment, I need to do a codicil, I would review it to determine, hey, do we just make an amendment, do we edit or revise the will itself and re-execute, or is it something that it warrants having creating a separate one and then executing it? But if it's within that first 3-year period or window with me, it wouldn't be an additional cost if it's something minor. But like I said, I can't speak for all uh all attorneys. Okay, I'm gonna check here. All right, let me pull this back up. So there's some of the things I've already touched on, but just in terms of, I'm gonna put my pull my share my screen again. I have talked through some of this in terms of things to think about. But when we're talking about how to prepare, and if you're in a consultation with me, almost all of them start with, what are your goals? And so you want to, I say, identify the goals. What are your goals with your plan? What are your desires? You want to, think about who are your loved ones? Are there children or those with special needs? Excuse me, or are there organizations that you're a part of? I know a lot of times people want to don't leave donations or monies to their church or other nonprofit organizations. So, identifying, are there any of those organizations that are important to you that would you want to make a charitable contribution after you pass? Identifying what are your assets, and then what are the different types of assets that you have, whether you want to be buried or cremated, whether you want to have a memorial service or a funeral service, those details of what you want it to be. I know someone who they have already planned their funeral. They said that is the last event that they get to plan, and they want to make sure it's great. Um, if you saw, what was it, Coming to America 2, or the second one, I forget the actual title of it, King Joffrey said he wanted to see his funeral. So he had them plan it, and he attended his funeral so he could see how it went, and if everyone honoring him. So like I said, you can get as creative as you want to or be as simplistic as you'd like. But also think about, with respect to, how you want your remains to be handled, you can contact a funeral home or funeral service ahead of time, and you can prepay for burial, or you can just assume, if you don't prepay, you can at least plan it out and identify it, and then let someone in your family know, hey, this is what I've done. In terms of who you want to be buried, you could purchase a plot ahead of time. I know that's something that within my family, that is something that they did. My grandmother and her sisters are all buried in the same cemetery, and very close to one another. Plots are very close to one another. Another thing is, like I said, organ to body donation, insurance policies. If you do, I guess the first question is, do you have insurance policies? And if you do, have you designated beneficiaries, or do you need to update those beneficiaries? This comes up often in the situation where you have someone who's married, they get divorced, and either they remarry or they don't remarry, and that's a good time to check to see, hey, have I updated the beneficiary? Because with life insurance, as well as any other account where a beneficiary is listed, it doesn't matter what's in your will or in the trust. That company is going to go based on who is listed as a beneficiary. So example, like I said, if there's someone you had life insurance, you listed your first spouse on there, you ended up remarrying and you did not update it to put your new spouse's name as a beneficiary, when you pass away, that insurance company is going to send those funds to the first spouse regardless. And it will be up to that person to determine if they want to share the proceeds with the new spouse. But that's one of the things you want to keep in mind. And like I said, remember that it's regardless of even if you put in your will, I want, uh, because I think I had someone ask me this before, they wanted the life insurance payment to be used to pay for their funeral. And what I was explaining to them is I think that's great that you've had this conversation and that's admirable, but keep in mind that once you pass away, there's no way of guaranteeing that that person uses that money to pay for the funeral because it will be theirs to do with what they want. And so if it is a matter of if you know you are very specific about what you want, especially with respect to burial or a service, it's best to either have money in an account that is designated for that, or as much as possible, go ahead and prepay for those things. Um, Jumping ahead a bit, so when we were talking, once a person dies, some things that you will need to do or keep in mind is you want to contact or contract with the funeral home so that they can pick the body up and then you have a death certificate issued. Excuse me, and you start having that conversation about what are we going to do? You know, if you already know, then they can just kind of execute the plan, or you start that process of planning. When we're talking about life insurance, you want to make sure you contact the respective company, let them know that the person has passed away, provide them with the certified copy of the death certificate and whatever other forms that they require so that you can send that to them, especially if you are using the policy if you're using the policy to pay for the funeral, then you want to make sure you get the proper information to the life insurance company. If there are pension, retirement plan, Social Security, you contact the respective offices to notify them that the person has passed away, that you are a beneficiary, and then go forward with that process. Something else that should happen is if you any other financial institutions. So hopefully you have, or if you have not before, after tonight, you will contact your banks and set up a transfer on death or payable on death with your bank account. And what that does is it creates a beneficiary for your bank account. So that way, when you pass away, whomever you've listed, they can contact that financial institution and let them know, hey, the account owner has passed away. I'm listed as one of the beneficiaries. I would like to be able to access the funds in this account. This makes a big difference, especially if you need to access those funds right away, if it is to cover funeral expenses or just living expenses. And having the payable on death or the transfer on death set up is another way to avoid probate in terms of accessing those funds. Because if you don't have a payable on death or transfer on death set up for your bank accounts, then the personal representative or whomever is intended for those funds are intended for will have to wait until an estate is opened and go through the probate process, and then essentially for a judge to issue an order saying, okay, yes, financial institution, you can release the funds to them. And so if you've heard probate, I'm sure I've seen a lot of things lately, especially on social media about, you want to do stuff to avoid probate. Um, but just so you have an idea of what probate is, it is the process for distributing the assets when a person dies. And so whether someone has a will or not, you will go through this probate process. It's essentially letting the court monitor the process or manage the process. So like I said, each county has a register of wills or deeds that manages that process. And it's required when there are assets that need to pass to others, either by will or intestate succession. And in that process, you would need to provide the death certificate or and the will or a statement stating that there is no will. There are fees associated with opening a probate case, and it will be based upon the value of assets. If it is usually it's classified as either a small estate, regular, or large, and it varies. So if it's a smaller estate, sometimes if it's under a certain amount, oftentimes there is it's either free or a very nominal fee. Of course, the larger the size of the estate is, the higher the fee would be. And as I mentioned before, the personal representative is responsible for locating, accounting for, and distributing all of the assets in that person's estate. You also want to make sure that if there are creditors or creditor claims, this comes up oftentimes if there are medical expenses or if someone had credit cards or any other types of line of credit, they would need to send out a notice to the creditors that this person has passed away, and you put essentially when you send out that notice, you want to put a cap of, hey, you need to respond by a certain date if you want to, claim this. If not, it'll be considered to be waived. Okay, so some things to remember, and this is more of just kind of a summary, a reminder of, like I said, you want to make sure you're updating beneficiaries after major life changes. I would say think of it similar to how if you're working for an employer, there's that open enrollment period. So anytime there's a major life event, you want to check or review your documents to make sure that they still reflect your goals and wishes. Once you create a plan, an estate plan, it is not a set it and forget it. You want to check, like I said, for major life events. Also, every few years, you want to check it to say, hey, does this still match my goals or have things changed? Making, if need be, you want to update or change title name or the title of deed of property. You want to make sure that you're letting people know, your loved ones or someone trusted know that you've created an estate plan and where it is. If you're using um, a safe deposit box, sorry. If you have one of those, you want to make sure that someone else knows about it, and then you've listed someone as an alternate so that they're able to access it once you pass. So I would not suggest leaving your will in the safety security deposit, a security deposit box. Um, and then, like I said, thinking about your wishes, excuse me, also in this day and age of everything being digital, do you have passwords saved somewhere? Does anyone else have your passwords, or do they know how to access the accounts? I think all of the social media platforms now, they have set something up to where you can list people. You can essentially kind of list designated people to be contacted or to have access to your accounts when you pass away. Okay, so I'm going to stop sharing again. But as I mentioned before, the goals here are to, one, have a plan, put things in place, but you want to reduce stress and anxiety for yourself as well as for your loved ones. It also, having a plan helps to minimize cost in the future. And also, depending on what you decide to be your method of estate planning, whether it is a will-based plan or trust-based plan, there are the costs differ upfront, but then you also have to think about what is the savings in the long run, or what is going to be the least stressful for your family once you pass away. And so I know that I went over a lot of different things rather quickly, but like I said, to this month, it is just still, I'm doing overview, but in future sessions, we will go into more detail about a will, what are the components of a will, what are things that go into that, what you need, as well as talking about trust, what the trust is, how to set it up, some of the different types of trust, and kind of the pros and cons of each, but it really will depend on your situation, where you are right now financially, is also what is your, what are your assets? that you have right now? What are your goals in terms of what you're looking to prepare or plan for and protect? And then I will also have some guests join in future sessions talk about different aspects of estate planning as well as the estate administration side of things of, what does it look like after the person has passed away? And or if you have that, I'm now managing someone's estate, what that looks like and some tips and tools to help manage that process. Uh, and so, like I said, that is all that I have in terms of information to share. I do want to open it up again to see if there are any questions, uh, or just any questions about anything that I have covered or any questions you might have in general.
The transfer of debt. So it sounds like I guess we need to do an extra step. So if you have a bank account
Mhm.
and then you put a beneficiary, you're saying there's an extra form that we need to also fill out?
So possibly, so it's going to depend on your bank. And so most of the banks they have it. So hopefully it'll just be you let them know I want to set it up. And now with so many things being online, it would be that online their form. You would fill out the financial institution's form
Mhm.
to set up the transfer on death or payable on death. And the name changes depending on the type of account, which is why I'm saying that. But once you do that, there won't be anything else you need to do unless you want to change it. But it's just that you do that one time. And then once you pass away, the person who is listed as the beneficiary of that account, they would contact that respective financial institution, and to see what that process is from there.
Okay. And then maybe this is a future topic is for those of us who own businesses and we want, I don't know, in case something happens,
Mhm.
maybe not even before death. So in case something happens, like the business transfers over to an individual, I'm not sure. It's not really setting up a partnership. It's just saying when Brenda is not here or when something happens to Brenda, this person automatically has the business. I don't know what that is.
Sure, no, that is a great question, and I will do a
Oh,
session. We talk
okay.
solely about that, but what I can say is, so one easy way, if you have an LLC, or if you have an LLC, then you should have an operating agreement. If your business is a corporation, whether it's for profit or nonprofit, you have to have bylaws. And so one first step of that is making sure that in whichever operating agreement, whatever that agreement you have, you want to address that it's easier with an LLC. So in that operating agreement, you can write that in to identify this is who, a silent partner or one of the members, or even if you can put that into your operating agreement of specifying in the event of X occurrence, then person A has the authority to step in and act on my behalf to make XYZ decisions. If you don't have the operating agreement, or in the process of you try to get one created, then you could have a separate agreement with a person. Using myself as an example, I have one of my colleagues who's also an attorney, has their own law firm. We have an agreement that, in the event that I'm not able to address a certain matter, they kind of serve as my backup counsel for
Mhm.
things. Um, and as I'm saying that, I realize I need to update my operating agreement to reflect that. But so that it could be done in your operating agreement, or you could have a separate agreement or document, that you essentially enter into agreement with that person and put it into writing of these are the terms of if I have to have some type of procedure where I'm not going to be able to work for 2 weeks, or I need to recover for X amount of time, then hey, I'm making sure I'm keeping you up to date periodically so that you know what's going on, and that I'll put in any kind of out of office things that they know to contact that person. So I would say the primary way is in your operating agreement or bylaws. And then you can have the separate agreements also within your policy, if you have an SOP or policy procedures, kind of internal documents, you would want to list that stuff in there as well.
Mm.
One of the places I work, someone called it a hit by the bus book of in the event that somebody gets hit by a bus or something happens, you want to have something in place so someone else can come in and as quickly as possible start handling things.
Okay. And just so last question. So with that in mind, the individual has to be 18?
Who's making the will? Yes.
No, not making the will. The person who might be assigned to take over in
Yes.
terms of age,
As a for to be like your personal representative or in terms of taking over something for your business.
taking over for something in my business.
I would say it's good practice to have them be over 18 just because depending on what they would need to do,
Hmm.
most things you require to be, an adult to
Okay.
enter into an agreement or to conduct business on your behalf. So yeah, it's good practice to have them be over 18.
And then once you update the operating agreement, because I don't think it's something that's required with the state, but you can still submit it.
So yes, the operating agreement is not required. You don't submit it to the state,
Mm,
but it's very important. I strongly recommend having an operating agreement, even if
right.
you are a single member LLC, because like I said, you can do a lot of your pre-planning or it addresses a good operating agreement addresses all of those different components right there.
Hmm.
And
Okay.
of course, you can always amend it as need be.
Thank you.
Mhm. I'm gonna check to see if we have any questions over on my screen one last time. I want to say thank you for joining this month's edition of Legacy Conversations. Like I said, I appreciate you all joining. It's the goal, once again, is to provide information, also to encourage you to have these conversations with your own family and loved ones. I would be more than happy to discuss in further detail with you about your goals for estate planning or legacy planning. If you would like to do so, you can go to the website. It's lalegalsolutions.com, and that is solutions with a Z at the end, to schedule a consultation, or you can email me at Latavia at LA Legal Solutions if you have a question, a specific question about something in the session tonight. Uh, on social media, where I also post things periodically. It is LA Legal Solutions on all social media platforms. This session, as well as previous and future ones, will also be posted to the YouTube page. So if there's something that you missed or you just want to kind of go back and refresh or share with someone as a way of getting the conversation started, you can go to the LA Legal Solutions YouTube page and take a video, rewatch, or share. But thank you again.